access to justice. Before getting started, I would like to take a minute to thank our Super Saturday event partners, and that is Arkansas Access to Justice, the Friday Firm, Legal Aid, Center for Arkansas Legal Services, the University of Arkansas School of Law, Southern Bancorp, and Goodwill for making this CLE happen, and also for helping us out with the Super Saturday clinics. Later on, we'll be providing more information about the Super Saturday program. It's a fantastic program, and I'm hoping that after the CLE, once I send the link, that some of you will decide to volunteer. My name is Ida Chavez de Ceguera, and I have the honor to serve as the new program coordinator for Arkansas Access to Justice. Today, I'll also be the moderator. So before getting started, I'm going to start with a few housekeeping announcements. After this CLE, but before the end of the day, I'm going to send an email, and it's going to have all the estate planning forms that Caleb and Jordan will be referring to today. The email will also include a sign-up link in case you want to volunteer for the Super Saturday events. There's also going to be a certificate of attendance form on that email for those who stayed for the entirety of the CLE. And if for some reason you get disconnected, please just log back in, and then send me an email, and then I'll be able to track your time. I don't know if anybody wants to refer to the presentation afterwards, but if you do, it will be available on our YouTube channel. But you cannot receive credit for watching the CLE. You have to be live in order to receive the credit. I'm going to tell you a little bit more about what Super Saturday is. This event started in partnership with, like I said, Arkansas Legal, Arkansas Center for Arkansas Legal Services, Legal Aid, with Goodwill, Southern Bancorp, obviously the Friday Law Firm, and us. And so it started with the needs of certain areas of the population that were being underserved. And so they identified the need, and then decided to create a tax clinic and a legal clinic where, in this case, attorneys and law students can volunteer and serve by preparing wills or doing some record sealing. And so today we wanted to put together this CLE in order to give you a little more insight as to the estate planning forms, and also in hopes to get some of you to volunteer also with us. If you don't have the time to volunteer, you can always choose to donate money in support of Arkansas Access to Justice, Legal Aid, and the Center for Arkansas Legal Services. During this presentation, if you have any questions, just put them in the chat, and then I will raise them. We'll also leave 5 minutes at the end of the presentation in case anybody has additional questions. And with that, we're going to get started with our poll. Let me share that. I want to know who is in our audience. So if you don't mind answering this question, just choose the role that best describes you. We'll give 20 seconds to get that completed. We have pretty much everyone's responses by now. There's still about 30 people missing. Once that we end the poll, nobody can answer. Somebody asked me that in the previous CLE an hour ago. So please just enter your answer right now, so that way it can be counted. Okay, and let's see the results. So we have a pretty good crowd. It's a mix, but pretty much attorneys. That's the bulk majority, and there's 25% of our attendees that are members of the general public. I'm going to talk to you also about the dates and the locations, just gonna go over them briefly. If you decide to volunteer and put the skills that you learned today into practice, You can volunteer, and the dates are February 4th, the 18th, the 25th, and there's a couple of cities. There's in Eudora and West Helena and Little Rock, Luxburg, El Dorado, Blytheville, and also for attorneys that are licensed in Missouri, also in Indianola, Missouri. If you can, please, like I said, sign up. Without further ado, I'm going to start introducing you to our panelists. I wanted to thank them for their time. They really invested a lot of the time reviewing the forms. We're providing these forms to you for you to use, and those will be given at the end of the presentation when I send you that email tonight, because we're hoping that most of you will choose to volunteer and participate, donating your time to help low-income Arkansans. So I'm delighted now to introduce Caleb Hollinger and Jordan Sharp. I don't think that Jordan has been able to join yet, but I will go ahead and introduce him in case he's able to fix the technical issues. I'll start with Caleb. Caleb is an associate attorney for the Friday, Eldridge and Clark firm. He works in the Trust and Estate Planning Division. In 2021, Caleb received his master's in taxation from the University of Florida, and before that, he graduated from the William H. Bowen School of Law. While in law school, Caleb served as a judicial extern for Judge Richard Taylor in the United States Bankruptcy Court. Now I'm going to tell you a little bit about Jordan. He's an associate at the same firm, at the Friday firm. He practices in the same area, estate planning and trusts, and also does taxation. Jordan completed his Master of Law in Taxation in the University of Florida, Levin College of Law. He earned his Juris Doctorate from the University of Arkansas School of Law and graduated with honors. And while in law school, he served as a law review editor. Well, without further ado, I'm going to pass it on to Caleb.
All right. Thank you, Edith. And I want to say one quick thing. I noticed we didn't have any law students currently in the program, but I actually participated in a Super Saturday event in law school. We went down to El Dorado at Southern Bancorp, and it was an eye-opening experience for me, getting to pretty much get my feet wet in the practice of law, working with local attorneys, both in Little Rock and in El Dorado. And it really paved the way for what I'm doing today, which is mostly trust and estates work. So if you're on the fence about participating in these events, I would recommend that you do, just because, and especially if any law student ends up watching this, truly it's a very rewarding experience. As Edith mentioned, if you have any questions about the CLE, shoot her an email, and she'll be glad to take care of that. And so this presentation is going to be geared more towards those that are going to be participating in the Super Saturday event. So what we're really going to discuss here today are the wills and the forms that you will see, also the power of attorneys, the living will form, and then the beneficiary deeds. But if you have any general questions, Jordan and I would be happy to answer those. And I'm not sure if Jordan's going to be able to be on this video webinar today, but in the event that he is, he will take over when prompted. The first thing I want to discuss is the client intake. So through this program, you're going to get an intake form and a scope of representation form. And you're going to have the opportunity to review that with the client. And it will obviously be a limited waiver of this is a limited scope representation. It's going to be limited to what we're going to do today, which would be execute a will, any other ancillary estate planning document, and a beneficiary deed. And obviously it's going to be in writing, but you're going to want to make sure you communicate that clearly to the client. That way there's no misunderstanding after the event itself, that they're not calling you and asking too many questions. Obviously, you can feel free to answer those within reason. But you just want to make sure that the scope is clearly defined. That way there are no issues down the road. Again, we're going to be doing simple wills with these trusts. With these wills, typically it'll be outright distributions of the property. We may set up a trust in the event that the client has minor children or a special needs child. Those wills will set up testamentary trusts. We're going to do a power of attorney. Typically we do adults. I haven't seen a minor power of attorney, but we do have that form if that's going to be necessary based on the circumstance. We'll do a living will, which is your healthcare power of attorney. It's an advanced healthcare directive, if you would, and then a beneficiary deed for any real property that the client owns when they come in. So in this initial consultation, it's going to be very important that you get the basic background information from the client. Obviously, this will be a privileged communication. You're going to want to know any prior marriages, their children, their ages, where they live, where does the client live, whether they've been married or they're obviously currently married. You're going to want to get a general overview of their assets. And typically you're going to want to pay attention to whether these assets are probate or non-probate assets, meaning whether you can avoid the probate process altogether with the client. For example, any bank accounts they have, you're going to want to make sure that they have a POD, a payable on death beneficiary designated on such accounts. If they have any insurance policies, you're going to want to make sure that their beneficiary designations are up to date. So if you have any questions about that, I'm happy to answer towards the end of the program. But you'll want to make sure that all of the beneficiary designations on their non-probate assets are up to speed. You're going to want to see how their real property is titled, whether it's tenants in common. If they have a life estate, obviously they're not going to be able to execute an effective beneficiary deed because their interest will expire upon their death. So make sure you get a good grasp of their assets. Also in this process, you're going to want to see and ascertain whether they have a special needs child. We'll get into that a little bit later on the specific provisions. Whether they want to disinherit a child, if they have an estranged child or a estranged family member who is set to inherit, generally under the laws of intestacy, you'll want to know that. You want to know whether there are any poor money managers in the family. If that's the case, that's probably not who you want to have them list as their executor or any fiduciary in their documents. You're going to want to ascertain whether or not any close family members are convicted felons. That will disqualify them in certain circumstances from serving as a fiduciary. And you're going to want to see if there's any other individual that they want to include in their estate planning documents as a beneficiary, for example, that's not a member of their family. And in general, you're going to want to explain what each document is. And if they have any questions, I know I'll be at most of these events, and I think Jordan will too. Feel free to just give us, holler, and we'll come over and explain the documents. So I'm going to start with wills, and I think Jordan is going to jump in a little bit later, but in the event that he's not, I can go ahead and continue on with this presentation. So basically, what is a will? Well, a will is a written document stating an individual's wishes as to how their property will be disposed of at death. So it states who gets what, or in some cases, who does not get anything. It's revocable at any point prior to the testator's death, which is important. There are some basic, obviously you can see on the screen, there's basic terminology in the will's context. Your executor or your executrix, depending on the feminine or masculine, that's who's named as the personal representative who the testator names, and that person is in charge with the administration of the estate. He or she carries out the provisions of the will, is responsible for paying any taxes that the estate or the decedent owns prior to death, any taxes that are due. This person's charged with distributing the assets out to the beneficiaries, so on and so forth. A trustee, this is the person similar to an executor, is also a fiduciary. They're going to be charged with administering any testamentary trusts that are created under the terms of the will. So in our context, within the Super Saturday event, this is going to be the person who's going to be charged with maybe the special needs trust or the trust for the minor. Okay, so that's the trustee. They also have fiduciary duties that are outlined under Arkansas law. And you're also going to name a guardian. typically, and this will be, you'll use this provision if the testator is going to perhaps leave property to any minors, okay, and this is going to appoint somebody, and typically it's their children, okay, who's gonna represent them, their interest in the event that the testator is deceased and with minor children. Some basic requirements for a will, okay, is the testator must be 18 years of age. The testator must have sound mind, also known as testamentary capacity. And this requires basically that the testator understands the nature and extent of their property and the natural objects of their bounty. So with the nature and extent of the property, they know the real estate that they own in Grant County, or they know I've got a bank account at Regions, or, they don't have to know all of their property. Obviously, it's a majority of it, just know where it is and what they have. The natural objects of their bounty. Typically, these are the individuals who would take property under the laws of intestacy, or if they didn't have a will. So this is their lineal descendants, their siblings, their parents, any other collateral heirs. And of sound mind, it's a lower threshold than there is, for example, to enter into a contract. So it's a lower bar, but it's not. It's pretty outlined under the law what testamentary capacity is. So you've got to be 18. You've got to have testamentary capacity. The will has to be in writing, and it's got to be signed by the testator. And with an attested will, there has to be 2 witnesses, and these witnesses must be disinterested, meaning that they are not a beneficiary under the terms of the will. Now, if they are interested, what happens is they would forfeit what they would otherwise receive under the will. So if you're dealing with a will in a situation where the testator leaves everything to their kids, and one of the kids, if it's, let's say there's 2 kids, Alan and Bob, testator leaves property 50-50, equal shares, and Bob is a witness to a will, then he forfeits his share. But you say, okay, well, not a big deal. He's under the normal laws of intestacy, he's going to receive that property anyways. But where it is a bigger deal is when the interested witness is not an heir, and in that case, that person forfeits the entire interest that they were going to receive under the will. So it's very important during the initial intake, you clearly define, okay, who you want to leave your property to, or they are going to, and you got to ascertain whether or not they are an interested party. You have to have generally two witnesses. There is an exception where the testator, for example, is unable to sign their name, but they can sign by mark. And in that situation, you need an additional witness, so 3 total. And that additional witnesses the mark, and then you have your 2 typical witnesses that you would have in an ordinary will situation. You'll notice with the will, there's also what is known as a proof of will. And this is a sworn declaration that's made by the attesting witnesses, swearing to the will's due execution. This is signed by the 2 witnesses that witnessed the original will. They testify, or they swear to that the will was executed by the testator. They witnessed the testator's signature. The testator appeared to be 18 years of age, of sound mind, when the testator executed the document, and the testator was free. The proof of will, what it really does, it eliminates the need to have the witnesses appear in to testify as to the accuracy and veracity of the will when there is an uncontested probate of the will. Now, we'll in this Super Saturday event, we won't be dealing with attested wills, but holographic wills, but I want you to know what a holographic will is. And since we're dealing with mostly attorneys, you guys probably know this. It's a will that's entirely handwritten in the testator's handwriting. And in a situation in practice, if you're dealing with a holographic will, you're going to have 3 witnesses to testify as to the testator's handwriting. Other subsidiary rule of a will is a codicil, okay, and that's just an amendment to the will. It has to be executed with the same testamentary formalities as the will. when executing, typically with a codicil, what you'll be doing is when we execute codicils, we're changing maybe a fiduciary under the documents. So maybe the named executor, executrix has passed, the testator is still alive. So, and there wasn't a backup named, we'll use a codicil to change the name or change who the fiduciary is. Again, has to be executed with the same testamentary formalities, and you're going to want to make sure that you republish the existing previously valid will that was executed, to the extent that it doesn't, to the extent the two are cohesive and it doesn't overrule what was said in the codicil. Generally, a will must be probated within 5 years against death. So once you'll see the form, and I would share it on here, but I don't want to mess up what I've got going on with the presentation. But typically, with a document that we'll be using, you'll have a section for your fiduciaries. So you're going to want to, you'll ask the client who they want to name, and then ask for a backup. That way you'll say if Billy Jane is who I name as my executor, in the event Billy or Jane, let's say Billy, in the event that Billy cannot serve, then Jane shall serve. There are certain requirements for an executor executrix under Arkansas law. They have to be, it should say, it says under, this is all defined in the negative. So they've got to be over 21 years of age. They have to be of sound mind. They cannot be a convicted felon. So again, in the initial intake, important that you find out whether or not their named fiduciaries are convicted felons. If it's a corporation, they've got to be authorized to act as a fiduciary in the state of Arkansas. And so typically all of the trust companies are. I will say that most of these trust companies do have minimum asset requirements if you're going to name a fiduciary, a corporate fiduciary. It has to be a person that the court would find suitable. And if it's a non-resident, meaning a fiduciary who's not in Arkansas, you're going to want to appoint a agent for service of process for such individual, and it's the clerk of the court where the will is being probated. Some more formalities. You'll list who the property will go to on a given paragraph. You'll basically, we're going to be executing simple wills, so the property will be going outright to these individuals. So, and then, like I said, the two exceptions will be if there's a minor, or if you're dealing with a special needs beneficiary, we will create a testamentary trust. And there will be a specific section where you name the trustee for those trusts. So you'll want to work with the client on who they vision taking over in the event a trust is in place, and making sure that that person is trustworthy. We have 3 different forms. We've got just an outright will with a distribution of assets to special needs, and then a minor. So again, make sure if it's a special needs beneficiary, if there is a possibility that there's a special needs beneficiary who's going to inherit anything under the will, you're going to want that language in there. Another thing with the wills, on one of the first paragraphs below, the testator will name if they're married, who they're married to, and their children. And important because under Arkansas law, we have what is known as the pretermittent heir statute. And in the event the testator does not name a child of theirs, the law presumes that they meant to name the child, and then that child who is pretermittent or left out will be entitled to take their intestate share and testate share. So we're going to want to make sure that we get all the kids, make sure they're named, even if they're estranged and are going to be disinherited. You still want to name that child, that way they don't inherit, if that's obviously consistent with the testator's witnesses. And then keep in mind that we do have dower and courtesy laws in Arkansas and spousal elective share rule that enables the surviving spouse to elect against the will and take what they would normally get, which again would depend on whether the testator was survived with children or not, and then how long the marriage. There are different rules that would come into place there to determine that share. Also, like I said, you can name the kids. You don't have to leave them anything if you wanted to disinherit them. And then also you can name them as a class. So example, you would name their kids, if, Alice and Bob, if then living, or if not then living, they're then surviving descendants. That would take care of that class below them. When executing the will with the client, typically you're just going to want to have the witnesses to the will and the testator. So if the testator comes in with their daughter, Susie, you're going to politely want to ask Susie to leave the room, because you're not going to, you're trying to avoid is having a situation where undue influence comes into play. You want to take all of that out and make that just be a total non-factor. So you're going to want to make sure that whoever's in the room executing the documents, it's limited to those that are absolutely necessary. Again, the will be signed by 2 witnesses and a notary public. The notary public cannot be a witness, so you'll have to have 2 witnesses and a notary public. Or in the event that the testator signs by a mark, a witness to the mark, 2 attesting witnesses and a notary.
And I think this is a good point to ask the first question, if you don't mind, Caleb.
Yeah.
Anthony is asking, is the spouse of a will beneficiary an interested person?
I'm sorry, what was that? Is a will beneficiary an interested person?
The spouse of a will beneficiary.
Yeah, would be an interested person.
Okay.
So don't
I
have
hope
your
that-
spouse as a witness. Yeah, good question.
Thank you. Good question, Anthony. And so the next question we have from Don is a simple will okay if you have no family or relatives?
Yeah. Well, let me ask you this. A simple will, no family or relatives, assuming that the testator wants to leave property to like maybe their best friend. In the event that they didn't execute a simple will and they truly desired all their property to go to their best friend, they didn't execute that will, it's going to pass to their collateral heirs, okay, under the laws of intestacy. And then there's a table of descents in the Arkansas Code. Typically, it starts with your children. And then if you have children, everything would go to your children. If no children, you have a surviving spouse. And it depends on how long they were married, whether the property, if the property that's going to be passed is ancestral property. So then you start with kids, parents, or kids, surviving spouse, and then it goes, I believe, siblings. You don't have any siblings, and it goes to your parents, then your siblings, and no siblings, and you're like, okay, we'll go to your aunt, your grandparents, and it goes, there's a table of descent. So to answer your question in a roundabout way, you really want to ascertain whether the client wants to leave their property to somebody who would not take under the laws of intestacy, or whether they would agree with the laws of intestacy. Just as a general rule of thumb, it's good to have a will, because you avoid that situation where if you really didn't like your brother or sister, they're not taking your property. So
Perfect. Thank you. And we have 2 related questions. These are about holographic wills. Terry and Scott are asking if you need the 3 witnesses to be able to be present during a holographic will execution, or just the handwriting.
no, they're just going to attest that that is the testator's handwriting.
Thank you.
I'll pick back up with what we have here, the left in this slide. The forms that we have that we're going to be using for the Super Saturday event, they do not include a separate page for a personal property memorandum, but Arkansas law allows the testator to execute a personal property memorandum. And again, this could be handwritten, so it doesn't have to be typed or consistent with the will itself. But what they're going to want to do is it's truly personal property. So jewelry, guns, anything that they want to leave to a specific beneficiary, they can. Okay. And the way the will form is set up, it'll say personal property is going to go to A to the extent that it's not taken care of under the personal property memorandum that's attached to this will. Okay. So at any point, even if it's after the execution of the will, they can execute this personal property memorandum. And they're going to want to list the property, the beneficiary, and just date it. Okay. And again, it's personal property. So it's not real property. It's not securities. So it's not stocks. That's not covered. Property used in a trade of business. That's also not covered. And then any evidence of indebtedness, like a note, that's also not covered. You can't assign a note in a personal property memorandum. So I know that was very broad and pretty quick, but if you have any questions, you can just leave them in the chat now, or we can get to them at the end. But have next, Jordan has joined in, and Jordan will be covering the other ancillary documents that we will be preparing in conjunction with a will. So Jordan, I'll hand things off to you.
Well, Caleb, why don't you keep the PowerPoint up on your screen, and I'll just prompt you to advance it. That way we avoid any technical issues on my end. So glad to be here. Glad to be, speaking to you all about, just, basic estate planning, and just a great opportunity for, us in the legal field to help Arkansans, with just basic needs that they have. And so it's really cool to be a part of that. So the first primary ancillary document that we typically see with estate planning is a power of attorney. And so whenever you hear the phrase power of attorney, we want you to think about a financial power of attorney. And so this power of attorney is whenever a person who we refer to as the principal gives the attorney, in fact, who we can also refer to as the agent, they give that agent the power to essentially step into the principal's shoes and act on their behalf. And so with the power of attorney, there are two types. That is a springing and a durable. And so a springing becomes effective upon the incapacity of the principal, who, will be your client in this situation. And so in the documents that you will have for these events, it will require that a determination of capacity by a medical doctor or multiple medical doctors for that person, in order for the appointed agent within the power of attorney to act on behalf of the client. And so just to kind of summarize it up, a person would, have to be unable to act on their own. Basically they're incapacitated, not of sound mind, they're, in a coma of some sort. Then at that point, the appointed agent would need to get a letter from a doctor who is stating that this person is incapacitated. And then the person who is appointed as the agent can now go carry out the basic financial responsibilities for that person. The other type of a power of attorney that we see is a durable power of attorney. And this is much easier. It's effective right when it is executed. And so there's no need for a letter from a doctor to determine that somebody is incapacitated. It's just a lot cleaner. Now, there is some, a decision to be made for the client in this situation. If a client is on the younger end, a springing power of attorney may be a better choice, just because we typically expect a younger person to, not become incapacitated anytime in the near future. But that's always a possibility, just, things happen. Whereas with an older client, a durable power of attorney may be the better choice, just because they are on the older end. They may have surgery, they may unexpectedly go into the hospital and be unable to make decisions for themselves. And so that's just kind of your thinking whenever you're having your conversation with this client. Those are the things that you need to be taking into consideration. But then you need to present those two choices to the person, and you need to let them decide. But just make sure that you explain the difference of, a springing power of attorney and a durable power of attorney. And then in the form that you all will have, you're going to have the option to make it a broad power of attorney, or you're going to have the option to limit the scope of the power of attorney. So your basic powers generally include, for the agent to be able to go to a bank and to, handle all your bank affairs, whether it's to deposit money, whether it's to, take out money. It can be to pay someone's bills. It can be to, you can appoint a power of attorney, an agent to handle a transaction for you, such as buying a house or, a vehicle. You can appoint a power of attorney for, someone to speak to, a social security person. It's very broad what you can do. But so on the form that you have, there's a list where you'll be able to go through with the client different powers, and they can either say that they want their agent to have that power or that they do not want that agent to have their power. And so what you'll need to do is you'll need to just go through that list with them and discuss those with them and see what they exactly want for their power of attorney. I know Caleb and I generally, we tend to lean on the side of having a broad power of attorney, just because there's so many different aspects from, a person's finances and financial decisions that come up whenever they are incapacitated. It's just sometimes it's a little easier for the agent to have broader power. And so there's not any questions as to what that agent may or may not do. And then thinking about who you want to serve as that agent, you want to adhere to similar rules that Caleb talked about in choosing an executor or an executrix. You want somebody who you trust, who you think will do a good job of handling finances and being able to make wise decisions. And then you also want someone who's going to act in your best interest, and someone who's not going to use their fiduciary position to benefit themselves. And so whenever you're talking about an agent for their power of attorney, you need to just reiterate those things and make sure that they make a proper choice. And then another thing, a person may want multiple agents for their power of attorney, and that is perfectly fine. The decision that comes there is you need to ask the client whether they want multiple powers of attorneys to act jointly, or if you have 3 or more, whether you want them to act by a majority decision. So just keep that in the back of your mind if you come across a client who wants 2 or more persons named. And then it is also a good idea to have a backup attorney, in fact, a backup agent for this purpose, just in the event that the primary person who is named is unable or unwilling to serve in that capacity. And then whenever we're signing this document, it also needs to be notarized. No witness requirement, but it does need to be notarized. Caleb, if you want to go to the next one for me.
Yeah, Jordan, I'll add one more thing too. With the power of attorney, you're going to want, when you're executing it, you're going to want to revoke all prior power of attorneys if that's consistent with the client's wishes, because any prior power of attorney is still effective until you expressly withdraw it. So you don't want to have a situation where you've got 3 people out there when the client really only wants 1 agent or attorney. In fact, you don't want to have 3 out there that are just playing and win and just could mess things up totally. So make sure that you revoke any prior powers that have been granted, if that's what the principal or client wishes.
Yep. And I
There
believe
too, I'm sorry.
I
Go
believe
ahead,
that the form that you all will have does revoke prior power of attorney, but we will double check that.
And there's a related question on the Q&A and also on the chat. One of them is asking if the statutory age of majority under the Arkansas Code annotated is, what is that age of requirement? For you to be a person, as a personal representative, as an agent.
So for a will, you have to be 21, but for Arkansas to serve as an attorney, in fact, unfortunately, it's 18. I wish it were higher, but whenever you're explaining to a client, you need to take into consideration really the maturity level of who you're naming as agent. And it's really not the best idea to name a person under 21 in that role. And, you know, going back to what Caleb said, it's really best to have the person that you name as executor or executrix to also be named as the agent for the power of attorney, because they're very similar roles, because the estate is going to be handling the, you know, the financial assets of an estate after death, whereas a power of attorney is handling the financial assets of a person's estate prior to their death. And I should have said this earlier, but a power of attorney, that ceases to be effective at a person's death. And so then we move to, you know, the executor role. So but typically we want to see the same person named as agent as is named the executor or executrix.
And talking about the people that you name as agents, we had a question on the chat that said about naming family members. So Matt asks, what is the best way to prospectively overcome the issue of presumption of undue influence when a beneficiary, like a trusted family member, helps facilitate the will?
So with naming family members in this position, that is fine. I would just go back to say, you know, just make sure it's a family member that you trust. If the person is truly worried about, you know, undue influence or, you know, possible, you know, fraudulent behavior, you know, where somebody's going to use their position to benefit themselves, it may be wise to name another person, you know, a co-attorney, in fact, and have those two act jointly. And so that those two people have to agree on a decision. And so that way there's two people, or it could be three people who are involved in the decision making, and then there's not just one person who's making all the decisions.
Thank you for answering the question. We have one more question, and this one is related to the holographic will. They're asking if they need to have the original holographic will, or if it can be a copy of that as valid.
Keep both. I mean, generally with a holographic will, I would probably try to probate the original. Certainly you could try the copy of it, but the original would probably be best in that situation, since it is truly a holographic will.
Thank you. And I know that you touched on earlier, Caleb, on the pre-admission statute. Pew asked if you can disinherit an estranged wife under Arkansas law, and if that is subject to dower and courtesy.
Are they married? In the example, if they're married, they're still going to have, unless that, well, you can waive for the most part dower courtesy in a premarital agreement, but if they're married and there's no such agreement in place, they're going to be subject to the spousal elective share rules. Now, granted, this is kind of off the tangent, but that is subject, that's probate property. If you had a trust set up, now obviously there is some case law out there where one spouse sets up a revocable trust to try to take out or negate his or her spousal elective share for their spouse. I've read that's a scenario where it doesn't fly, but generally it's your probate assets that are subject to the spousal elective share. So, for example, if you were a beneficiary of a trust created by your parents or grandparents, that's not subject. It wouldn't be subject to any spousal or dower courtesy or spousal elective share, because if drafted properly, that trust that spouse is a beneficiary of, it's irrevocable. You have non-general power of appointment, so that's outside of that individual spouse's estate, and so that can't be touched. There's a layer of credit protection there. Again, this is off on a tangent. It's really outside of the scope of what we're covering today, but that's just a little tidbit.
Thank you.
All right. Another document that the clients will have available to them is a power of attorney for a minor. And what this allows a parent or the child's legal guardian to execute this power of attorney, which gives another third person authority over that minor child. And similar to the financial power of attorney we just talked about, it can be broad or it can be limited, and within those forms it'll have those specific powers in there. And then so you'll just want to make sure that you go through with your client, what those different powers are and what they may need. And then the parent or the legal guardian needs to sign this document, and it needs to be notarized. So Caleb, you go to the next one for me. Perfect. All right. So the next couple of documents are a living will and a healthcare power of attorney. So a living will is a document that comes into play whenever you have a person who is, in a very bad situation, at the end of their life, and they are receiving, life-sustaining treatments, artificial nutrition, and so forth. And so what the living will does, it specifies what the client wants or does not want in this situation. And then further, it appoints a healthcare proxy to which the healthcare provider are going to look to for a decision. They're kind of the person who they would look to is, whether we're going to stop giving them life-sustaining treatments or stop giving the nutrition or pulling the plug, those types of things. And so with this, you just want to have the client name somebody who they would trust to make those right decisions in that moment, and also to carry out the client's wishes. And whenever you're talking with your clients about this, it's sometimes a very hard discussion because a lot of people haven't thought about this. And so it may take them a few moments to figure out what exactly they want. And so just keep that in mind. And then similarly, a healthcare power of attorney, it is designating a person for just general healthcare decisions in the event that somebody were incapacitated. And so think about the living will as more specific to more end of life situations, where the healthcare power of attorney is much more broad, and it does not necessarily apply to end of life decisions, but just kind of focuses more on general healthcare decisions that may come up when the client is incapacitated. And generally, you want the same individual to serve in this role, just because they are very similar roles. And, say a client went in the hospital and they were, incapacitated, and the doctors were looking to the healthcare attorney for, specific decisions, but then the client took a turn for the worse, and now we're talking about end of life decisions. It's just smart to have that healthcare power of attorney also be the healthcare proxy, because they know everything going on. And so, and likewise, this needs to be, notarized as well. And then it's also good for the clients to have these documents available, somewhere accessible for the named parties to get access to them, just so that if there were a need for it in a quick moment, then they are available. And also, you also may want successors named in these two positions as well. So, all right, Caleb, I'm good. All right. So the last document that you all will have is a beneficiary deed. And so a beneficiary deed is a document that conveys real title to, whoever the grantee is. The key with a beneficiary deed is that it is effective upon the death of the grantor or grantors. So whenever you have a single unmarried person, at that single unmarried person's death, the beneficiary deed operates to automatically transfer whatever real property is described in the deed to the grantees. And that could be, the person's children, or it could be, a charity. It could be, whomever they choose to put in that position. Now, if you have a married couple, then a married couple who are both the grantors, and they were saying, they want to deed their house to their son. All right. So both the married people would be the two grantors, and you have one grantee. Upon the death of the last of the married clients, that is when the deed will become effective. So, say the husband dies first, well, then the surviving spouse, the wife, she continues to own the property in her personal name for the remainder of her life. But then upon her death is when the property would then automatically transfer to the son. And so you want to make sure, ask your clients, are you married or are you not married? Because it makes a difference for the beneficiary deed. And then another situation that you could come into is whenever you have a client who is married, but his spouse is not there, or one of the, married persons owns property in their own personal name. Well, because of the dower courtesy rules in Arkansas, a spouse has a life estate and 1/3 of real property after a person dies. And so if that property were transferred without the spouse releasing their dower or courtesy rights, then such spouse can have a claim against that property for the remainder of their life. So say a husband owns a piece of land and they want to give it to their son. This husband is married, but the wife does not own a part of this land. The husband and the wife need to be named as grantors in that deed, because we need the husband to transfer ownership of the property, but then we also need the wife to release her dower claim in the property at the same time. So in this situation, you will want both husband and wife to sign the deed, and they will both be the grantors. All right. And so that's just whenever you are talking with your clients and they have real property and they're wanting to pass it, you need to figure out exactly how that property is titled, and you need to figure out whether they are married or not. And then the beneficiary deed, it needs to be recorded. I believe, the clients, they are going to be responsible for recording their own deeds, and then they just need to take that to the circuit clerk in the county, wherever the real property is located. So I know, that could be DeShay County, it could be Union County, it could be Mississippi County. It just depends on where the Super Saturday event is being held. So I talked about that, about the first point. A beneficiary deed, it can be revoked prior to the death of the grantor. They would just need to revoke it, or they could execute another deed. And so that's really it. One thing, used to, DHS could make a claim against real property that was passed through a beneficiary deed, but now that is not the case. And so you may or may not have questions that come up with that, but just have that kind of in the back of your mind in the event that were to come up.
Any questions?
I think this is a perfect time to start our Q&A. We have a question from Victor, and he asks, for a minor POA, must both parents sign?
That would be the best in a perfect world, just because what you are doing is you are giving the power to do whatever it may be to a third person. And, my limited knowledge of family law is, we all, we have parental rights. And so first you're going to look to a parent to make a decision for a minor child. So the last thing you want is a conflict as to who can make the decision. So, but, in these situations, you may have, divorced parents who, one of the parents is the primary decision maker for, education, financial, and, health purposes. So in that situation, if that's the case, then you're probably fine with, just having that parent who has that specific authority to make that decision and to give that power. Another thing with minor power of attorney is that it can be temporary, it can just be for a weekend if need be. And then you will also have a form that revokes that power of attorney for the minor. available to you as well. So if they do execute one of those, then you'll want to educate them and show them, hey, this is how you revoke it.
Fantastic. And then we have another great question from Victor, the same person. So he's asking if attaching the divorce decree or a custody agreement that provides a primary custody on one parent has any bearing on who can and cannot be assigned under the power of attorney.
That I do not know. Caleb, do you have any idea on that?
I do not.
Yeah.
If you want to shoot us out in an email, though.
Yeah, we can take a look at that.
Okay, Victor, I'll provide the email in case you want to send a follow-up email. And then we have another question, and this is in regards to, it looks like the Arkansas Code Annotated. They're saying that the last time they looked, Arkansas Code Annotated showed that the language was to be used for a power of attorney. But if the language is still in place, if it's okay to vary it a little bit when preparing the form, or you have to stick to it verbatim.
You don't have to stick to it verbatim. It just, we just need to make sure it's in compliance with Arkansas law. And so, I mean, it, you know, I know the Arkansas code provides a standard form, but I know for our purposes, Caleb, we don't, we base our power of attorney forms off the standard form, but we deviate a little bit from it as well.
Yeah, and it also depends on the client's wishes. If they want to limit the scope of the power of attorney,
Yep.
Obviously they can do that. So if they just want it to be, you know, access to bank accounts, or, you know, able to draw or write checks on behalf of the principal, we can do just that too. So.
Perfect. And Johnny has another question. She's asking, during the intake process, do you need to know about any outstanding debt on the property they plan to disperse? If so, how far in the weeds do you need to discuss what happens with the debt after the death?
For the Super Saturday, then you'll definitely want to know whether there's debt on the property, because with a beneficiary deed, the property that's going to be transferred is subject to that mortgage and that the mortgage note. So that is very important to know, and to note that you might want to just educate them that this property, you know, in your estate, it will still pass pursuant to that debt, meaning your estate's either going to be on the hook for it or whoever your beneficiary is. And that also any debt that happens or you have at death, you'll need to open a probate estate that way, and that your heirs won't be liable for your debts. That's another big thing to help on that. And kind of, if you don't have much of a knowledge on the probate process, just reach out to one of us. We'll be there. We'll kind of describe what happens after death with a will. And then also there's a small estates affidavit out there. So if you're dealing, in this case, if we're dealing with clients who may not have a astronomical estate, the estate is under $100,000, you can execute the small estates affidavit that will effectively transfer the ownership without the necessity of a formal probate proceeding. And you would file that in conjunction with the will. That way you show the court, here are the assets, here are the values, they're under $100,000. Here's the will, here's where the property, the testator desired, and the decedent desired the property to go. And that way it's all consistent.
And one more thing on the small estate affidavit, you are required to make sure that any claims against the person's estate are paid prior to filing that small estate affidavit. So,
Yeah.
You know, that could be
May not be able
hospital,
to file it.
credit card bills.
So
Just something to keep in mind.
Thank you. And we have another question from Blake. It says, can I add the language, that language to the general medical POA? And it's relating, I guess, to the living wills language.
Are you saying you can have them in this? Are you asking whether you can have them in the same document? If so, yes, you can, you know, make them into one document. You know, we do that.
Yeah, the General Power of Attorney Act typically doesn't handle, if you look at it under the code, it's not really meant for the healthcare purpose. There's a whole separate code, title and chapter for medical agents. So we usually just keep them separate, but I've seen documents where they're both included. They're just in the code, they're just in different spots for what it's worth. And it might be easier if if the client wants to name different fiduciaries to keep them separate, rather than having the same document, that way you avoid any kind of confusion on like which fiduciaries their role, like if they're acting as medical or if they're acting as generally like financial under a general durable power of attorney.
Makes sense. Another question, and I know I want to be mindful of everybody's time, so we'll answer 2 more questions. And if we were not able to answer your question, just send me an email. I'm going to provide my email in the chat. And also you'll receive an email from me as well before the end of the night, and it will have your certificate of attendance form. It'll have the link and the contact information for Ivan Martinez, who is the person in charge of coordinating the pro bono volunteer attorneys and students. And then also I will provide all the materials that Caleb and Jordan have been referring to. So the second to last question, what if a person dies without a will, leaving a spouse and children? The spouse is not the biological or adopted parent of the children adult. Are the adult children entitled to any shares of the marital home of their deceased parent? And they apologize for the long question.
Jordan, you want to take this one, or you want me to? handle it?
Yes, so dies without children.
With children, without children.
Yeah,
Dies without a will, leaving a spouse and children, so the children are
children.
still alive, yeah.
okay. So in that sense, we're talking about intestacy succession. And so if they're children and they are the biological children, typically it's going to pass to those children. Now, if the spouse is the biological mother or father of those children, then it's going to be fine to pass to that spouse. But if they are not, if the surviving spouse is not the biological parent of those children, then it's going to pass to those children.
Dower courtesy comes off the top first.
Yes.
And then after that, you have your heritable estate, and then that's where you get into the table of descents and how the property passes.
Thank you for answering that one. And then the last question would be, if there is no will, does the person named in the healthcare power of attorney have authority as to end the life treatment or a life treatment?
Yes, that would be the living will. That's what that document specifically is for. And so if they just want to execute a living will to dictate how their wishes of what they want to do at the end of their life, whether, to withhold treatment, to have a do not resuscitate, or any of those other potential things that are named in the form, they are free to do that. They do not have to have a will to be able to do that.
Great. Thank you so much, Caleb and Jordan, for your insight, for your time, and especially for also reviewing the forms. I definitely wanted to thank to our partners, especially the Friday Law Firm. And I want to encourage everybody to please volunteer if you can for the Super Saturday events. Put those skills that you learned today to practice. Thank you and have a great day. And I think with that, we conclude the CLE. Thank you, guys.
Thank you.
Thank you.